Carolyn Elefant, everyone. She may have transitioned to the slideshow. If she does, I probably completely screwed him up, so we'll do our best.
My 13-year-old did the transitions, and now she's going to see it on the slideshow, think that she messed it up when it was really Matt. Anyway, so how many lawyers does it take to innovate at Biglaw? The world will never know because it happens so infrequently. Part of the reason is because lawyers hew closely to precedent. That's how we study the law. Part of it is we're just traditionalists, and part of it is just the nature of a large organization. It doesn't really lend itself very well to a culture of innovation. But there is innovation in the profession, and it thrives among solo and small firm practitioners. We're the architects of the contingency fee, which is the great granddaddy of alternative billing. We were pioneers with both traditional and online advertising. Joe Flom took a concept off the scrap heap called hostile takeovers, built it into a billion-dollar law firm at Skadden, and also we just had the parents of spam, it's Kenner and Siegel, two solo immigration attorneys. So to capture innovation, how do we capture that innovation at big firms? And the answer is we really can't. And large organizations have realized that too, which is one reason why they're outsourcing innovation. And so that's what I'm going to talk about today, a model where we can marry the resources of the large firm with the innovative spirit of the smaller firm. And the example that I'm going to give is Tommy Supreme. Tommy Supreme, a.k.a. Tom Goldstein, he is a real person. About 10 years ago, he started a practice dedicated exclusively to Supreme Court litigation. He started out small, doing work for free, eventually built an empire, and sold it to Aiken Gump, where he today presides over their appellate practice. So it's very much like a company like YouTube, three guys starting a video service, selling out to Google. Anyway, another thing that was unique about Tommy Supreme is that he changed the nature of Supreme Court practice. That's the Supreme Court circa 1886. The other is today. You can't really tell the difference. What he did was he came up with the concept of ambulance-chasing Supreme Court cases. Essentially what he did was he identified circuit splits, went to the people, the litigants in the case, and said, hey, I'll handle your case for free. Because that's what he knew, is that if he could get face time in front of the court, he could convert that into currency. And today, most large firms are ambulance-chasing cases. These are some of the other ways he innovated. Technology replaced ideology in this firm. Instead of looking at cases that had grand, lofty First Amendment principles, he was crunching numbers through a program he created himself, finding these circuit splits on these clunky issues and bringing them to the court. And in fact, many commentators have said that the nature of the docket at the court is different. He understood the power of free, as I said before. He knew that if he could get face time at the court, he could convert it into something that was very valuable. That's what is very common now with companies. The reason that they're giving you software as a service for free is that they realize that if they can get you in a little bit on a trial basis, they can sign you up longer term. The third thing he did was he bootstrapped. It was very common for people starting appellate practices to open up fancy offices, send out these engraved business cards. He started his firm out of his home. He took the cases for free. He approached Professor Lawrence Tribe at Harvard, and he started doing contract work for him, and eventually he grew his firm larger. The other thing you realize is that he focused on a niche. His firm's tagline is, we do exclusively Supreme Court litigation. What's the advantage of that? Well, first of all, you stand out. Who the heck does just Supreme Court litigation? Second of all, you make the best use of your marketing dollars because you have a focused target effort. And the third thing is you convey an aura of expertise. The fifth trend that he took advantage of was blogging. His blog on the Supreme Court came out in, I think, September of 2002. He invested money. He hired a journalist to do it. But what happened was it became the go-to source for information on the Supreme Court, attracting journalists and in-house counsel. So he made himself known through that. The sixth thing that he did was he expanded the pie. Only 77 cases a year go up to the Supreme Court. He knew he couldn't necessarily compete with lawyers getting those cases, so what he did was he started Supreme Court clinics at Harvard and Stanford. He had all of these students writing cert petitions. More cert petitions to the court, more cases granted, more cases for Tommy Supreme. Seventh rule, he hustled. There was a case that was involved a death row litigant. He was on the plane to meet that client before a large law firm could even get a management committee together. He cold called people for cases. He he did this work outside of his firm. The last thing he had also was he had passion. He danced. One of the things we hear about the law is always complaints, but there are actually people in this profession who love their job, and look at how it drives them. He brought his wife into his practice. He even he eats, sleeps, and breathe Supreme Court litigation, even naming his daughter Nina after Nina Totenberg, who's the commentator for NPR and Supreme Court. So why does this matter? Well, about a year ago, law firms were paying associates who they didn't have enough work for $60,000 to go and sit on their butts or travel around the world. What if those firms had taken that $60,000 and given it to the million other Tommy Supremes out there, given it to attorneys who would have started virtual law practices to provide access to law, to people to figure out how cloud computing works? And so one of the reasons why this business model matters, why we have to allocate these resources, is because there are people who have come into this profession who are in debt now, who are unemployed, and whose jobs are being outsourced or globalized or routinized. But firms still have resources, and they can allocate these resources to help people. The other reason why we've got to start outsourcing innovations is because I believe that we do need lawyers. In the 21st century, we're being confronted with all kinds of complex problems, and we need lawyers not to litigate, but to help allocate risk, to minimize uncertainty so that we can move forward and resolve issues like the green energy and the cloud computing and access to law. The last reason why this is important is our profession has been stratified for too long. We have big firms on one side, small firms on another, academics. That kind of separation is inefficient, and the inefficiencies are complicated by the problem that Kevin mentioned of being governed by 50 different associations. What it's time for us to do is to tear down the wall that exists between large firms and small firms, to find ways to work together and to address the issues that confront us, and to march forward united into the 21st century, because I believe that with technology and with all of the possibility that lies ahead, this will really be the finest hour for the profession. Thank you.